To continue this conversation on executive orders and the executive branch's overreach and how we as American citizens need to fight back is the General Counsel and Executive Director of the New Civil Liberties Alliance, Mark Chenoweth. Thanks so much for joining me.
Thanks for having me today. Great to be with you.
Absolutely. So for the average person who probably is looking at this in the headlines and politicizing everything, because we tend to look at this as Americans as if the Biden administration is doing it and we're Democrat, then that's totally fine. And if the Trump administration or some other Republican administration does it and we're Republican, then that's fine. But that's not really the constitutional divide. So in your words, explain the difference of how we need to be looking at executive branch's authority and the limitations.
Sure. So the president has the obligation to take care that the law be faithfully executed. It's Article 2 of the Constitution has the Take Care Clause. And one of the ways that presidents do this is to use executive orders, or it can be less formal than that. It can be an informal instruction from the president down to someone lower in the executive branch. No one thinks the president has time to run the entire executive branch by himself, of course. The problem is when these executive actions or executive orders are used to shortcut the legislative process, and when they start becoming legislative actions rather than executive actions, that's a problem. Or if they start to try to bind the conduct of people outside of the executive branch, then that's a problem. So if it's just the president telling his subordinates what to do, that's one thing. If it's the president telling his subordinates to do something to third parties outside the government, that's a much bigger problem if there isn't statutory authority for the actions that he's asking them to do.
So that gets into a conversation about the non-delegation doctrine. And so that's, for those people who aren't constitutional attorneys, explain that and what your organization is doing to fight that specifically.
Sure. So Article 1, Section 1 of the Constitution, right at the very beginning, is the vesting clause, is what it's called. And the vesting clause says that all legislative power is vested in a Congress of the United States. And so what that means, and then Article 1 goes on to specify what the limited powers of the federal government are, and it gives those powers to Congress, most of them in Article 1 in the legislative branch. And so to the legislative branch there. And the reason why the vesting clause is important is because Congress cannot give away that legislative power that it has. It can't delegate. The reason it's called the non-delegation doctrine, Congress can't delegate its power, its legislative power to the executive branch. And when it does so, that violates Article 1, Section 1 of the Constitution. Or if the executive branch just takes that power because there isn't any statutory authority for what it's doing, Congress never, for example, passed a law allowing the executive branch to do that, that also is a violation of the Constitution.
And so even when Congress would, for example, grant some limited authority and they do legislatively delegate, is there a difference, or how has the court parsed the rise of the administrative state in that way when Congress has essentially ceded their authority to the executive branch?
Well, the courts have been pretty reticent to do anything about it for about 75 years now, unfortunately. If you go back to when former President William Howard Taft was the Chief Justice of the U.S. Supreme Court. People may not realize he was the Chief Justice after being President of the United States, the only person who did that. He was obviously had a very thorough understanding of presidential power of the executive branch, and under his leadership, the Supreme Court actually checked executive power somewhat, and there were efforts to enforce the vesting clause. But sometime in the 1940s, we really got away from that, away from enforcing the vesting clause against the executive branch, and something called the intelligibility principle or intelligible principle doctrine got started. And essentially what the courts have said is as long as a piece of legislation has some intelligible principle in it that allows the executive to understand what Congress wanted, that's enough. Well, the problem with that is it could be that Congress is giving away too much power there, and there's nothing in that intelligible principle that has the teeth to stop the executive branch from taking too much power or stop Congress from giving away too much power. So what's exciting about today's Supreme Court is they've talked about potentially revisiting and reinvigorating the non-delegation doctrine, either putting some teeth into this intelligible principle idea, or maybe coming up with a different test for whether or not the vesting clause has been violated.
Yeah, and this is something that Justice Gorsuch in particular has been a strong advocate for. And I know a lot of conservatives, when he was initially nominated by President Trump, were very excited about to see that, he took this really hard line on the rise of the administrative state. And so looking at that as well, just for people who aren't as familiar with a lot of these principles and the delegations, we really have two separate operative constitutions in society. And that's what the Heritage Foundation article was getting at, which is that operationally we have all of these executive orders, we have all of these court orders that aren't necessarily the original text of the Constitution. And so what can we do either legislatively, functionally, or through litigation to try to roll that back into the original intent of the vesting clause?
Well, Congress should take back more power from the executive branch, and Congress has the ability to do that. Although one of the tricky things about giving away congressional power is once you've given it away, it is hard to get it back. And that's one of the reasons why I think that calling it delegation or calling it the non-delegation doctrine is a little bit misleading. Usually when you delegate power, if you think of a manager delegating power to an assistant manager, they can get that back by themselves unilaterally without the assistant manager's agreement, right? So that's what a delegation should be. But if Congress passes a law giving power to the executive branch, the only way to get that back is to pass a new law that the president has to sign, or you have to get both 2/3 of the House and the Senate to override a presidential veto. Well, we know how difficult that is to do. So if you can't get the president to agree to give up some power that Congress has given him, then it's going to be very hard to get that back. So I think it really shouldn't be thought of as delegating power. It should be thought of as divesting legislative power from the legislative branch to the executive branch. In terms of what we can do if Congress doesn't try to, Congress needs to stop giving away legislative power. But
Yes.
what else can we do? We can bring lawsuits. This is something that the New Civil Liberties Alliance does. Bring lawsuits in the federal court to try to get the courts to recognize some of the problems that have been created. So, for example, we have a lawsuit going against the CFPB, the Financial Protection Bureau, the Consumer Financial Protection Bureau, and our concern with the CFPB is the way that it is funded. It gets funded directly from the Federal Reserve and not through congressional appropriations. And last summer, the Supreme Court struck down one part of the CFPB, saying that the director needed to be someone who could be fired by the president, was not someone who could have tenure protection in that role. So now the CFPB has all this funding, hundreds of millions of dollars of funding, under the direct control of the president, and the congressional appropriations committees have no control over it. Congress has no control over the CFPB. It's really a runaway independent agency. Less independent now because the president can fire the director, but it's this funding problem is really a core. Appropriations is a core congressional power that they've given away in the case of the CFPB. So our lawsuit is trying to get courts to recognize that needs to be reined in, as one example.
That's a great example. And, when we look at Congress delegating, or as you rightly said, we should call this divesting, and I think that's an important difference. Why hasn't a more conservative Congress, for example, when Republicans controlled both the House and the Senate and also the White House, in your opinion, has this not been brought forward by either party? I mean, is it just something that functionally Congress isn't paying attention?
Well, I think it's tricky because if the Republicans are in control, for example, of the House and the Senate, but not the White House, then they're not going to necessarily be able to take back the power because a Democrat president isn't going to want to share power with a Republican Congress. And if you have a Republican House and Senate and a Republican president, a lot of times they're more interested in giving more power to the president or cooperating, working with the president to try to achieve some of their policy goals rather than use that opportunity to cut back on executive power. I do think we saw maybe more progress in the last 4 years than we've seen in, at least since I've been paying attention, because we did see some efforts at a type of deregulation that limited federal power. So, for example, in the area of regulations, President Trump issued an executive order, and so I guess maybe they're not all terrible, but he issued an executive order directing his agencies to not enforce guidance against anyone. So you have sort of standard regulations that go through the standard regulatory process, notice and comment rulemaking. But then you also have these little pieces of guidance that don't necessarily go through notice and comment. And sometimes agencies use that as a shortcut. They try to bind people with that. They try to enforce that guidance against people. Or if people don't follow the guidance, they'll bring enforcement actions against them on other offenses that the agency may, or not offenses, but other compliance obligations that the agency wants to enforce against those folks. And what the Trump administration said is you can't use guidance as an enforcement mechanism because guidance isn't binding. And the Department of Justice said the same thing in the last administration. Because guidance is not binding, DOJ will not bring enforcement actions against anyone based on a violation of guidance. It has to be a violation of a statute or a violation of a rule that has gone through the standard process. So that was a huge benefit from a civil liberties standpoint to all of regulated industry, but any Americans who face federal regulation, to know that they don't have to worry about enforcement actions based on guidance, which is often very hard to find in the federal code. Well, it's not in the federal code. That's why it's hard to find.
Yeah. And, Mark, this is such an incredibly important conversation. And one of those things that I really wish during the 2020 election, for example, I mean, this isn't an issue that maybe gets as many headlines or, is as sexy as some of the things that we typically tend to talk about in election cycles. But this is one of the things that President Trump really did to bring power back to the people, to our elected representatives. And that's one of the main reasons that so many people who actually understood the design of the Constitution really loved about President Trump and love about genuinely conservative leaders. So we're going to be right back with more of Just the Truth and continue the conversation with Mark. Welcome back to Just the Truth, and we're continuing the conversation with Mark Chenoweth, who is the Executive Director and General Counsel of the NCLA. You can find them at nclalegal.org, the New Civil Liberties Alliance. So, Mark, we're talking about this conversation of executive overreach, and so in this segment, I want to get a little more practical in terms of the examples, some great things that your organization is doing, and first, some examples of the Biden administration. Today is exactly 2 months into the administration, and we already have at least 37 formalized executive orders. We have even more executive actions than that. What, in your opinion, are the most egregious examples of the federal overreach of the Biden administration?
So, it depends what you care the most about. If you care about jobs, then it may be the executive action to stop the Keystone Pipeline, which I think was going to be a real job creator over the long term. If you're talking about the rights of American citizens, and that's something you care about, then maybe it's this travel ban, the Biden travel ban, which people aren't calling it that, but the Biden administration has said, and I should, full disclosure, this is left over from the tail end of the Trump administration, but it's been continued by the Biden administration. They're not allowing American citizens to return to the United States unless you have a negative COVID test. But some of the places where Americans have traveled are places where they may not have COVID testing available or not available at a reasonable cost. And so you're telling American citizens that they cannot return to the United States. Now, if they had these tests available at the local embassy or consulate, and it was just a matter of making a quick trip before you go to the airport, that might be one thing. But that's not what we're hearing is happening in these cases. So you're seeing violations there. One of the most concerning things I've heard about, and this hasn't happened yet, so maybe it won't, but what we're hearing is there was a rule at the Department of Transportation during the Trump administration that said that if there's an enforcement action against you, that the Department of Transportation would turn over what's called exculpatory evidence. Now, that's not a word you hear every day, but essentially it means if the agency has any evidence that shows that you are not guilty of what they are trying to come after you for, they have to share that evidence with you. And that's something that is standard practice in criminal trials in the United States. At the federal level, it's called your constitutional Brady obligation, and it's something that the Trump administration, the Department of Transportation in particular, was working into the administrative enforcement area as well. And we're told that the Biden administration is planning to pull back and eliminate this requirement for sharing exculpatory evidence. Now, why would they not want to share evidence with you of your innocence if that's in their possession. The government should be about seeking the truth, about only enforcing the law against lawbreakers, and there should be no problem with sharing exculpatory evidence with folks. So that's the kind of thing that the NCLA would look at suing the federal government over if it were to try to pull back this constitutional right to exculpatory evidence, for example.
Yeah, and so you mentioned earlier in the other segment that you're excited at least about the composition of the Supreme Court right now, which in and of itself I think is, it just shows how much we've politicized even the judicial branch to be concerned with the opinions and the policy positions of justices, but we have to be because we want to make sure that their understanding and their view of the U.S. Constitution is in keeping with the correct separation of powers of just one of many issues that the Supreme Court has to opine on and decide on. And so as the NCLA is litigating, I mean, we're only 2 months in the Biden administration, but what are some other things that you've seen in terms of your litigation success? And also, do you think that the federal courts on the lower court level are seeing that there's probably a difference in the composition of the court and are maybe changing their attitude towards some of this because they don't want to be overturned at the Supreme Court?
I hope that's the case. So, as you note, the administration is rather young, so there aren't a ton of lawsuits going yet. And I should mention too that NCLA is a non-partisan organization in addition to being a nonprofit organization. And so we had lots of lawsuits against the Trump administration as well for places where we thought that they had fallen short in following the Constitution. But one of the places that we have an ongoing lawsuit now against the Biden administration, again started against the Trump administration, is against the Centers for Disease Control and Prevention, the CDC, which issued last September a nationwide moratorium against evictions. And the problem with that, and again, we don't have a policy position on the wisdom of eviction moratoria or so forth. It's just that there is no federal statute. Congress has never given the CDC the power to do this. The CDC does not control housing policy. That's not their role in even the federal government. And for the CDC to issue this nationwide eviction moratorium without statutory authority, we think is a tremendous violation of civil liberties of housing providers in this case. And so we have a lawsuit going against them. In fact, we have filed a new lawsuit today against the Biden administration, a class action lawsuit against the Biden administration and the CDC over the same issue. But we also have a case that's still pending in the 11th Circuit Court of Appeals on the same issue as well. So we're trying to come at it from as many angles as we can to make sure that the Centers for Disease Control respects the limits, the statutory limits and the constitutional limits on its power. The CDC should not be preventing state landlord-tenant courts from operating, which is what it's been doing since last September.
And I love that you mentioned that as a constitutional organization, as someone who is legislatively trying to make sure that we're enforcing the rule of law in our country, that this is also the Trump administration, the Biden administration. This isn't just about partisan party politics, because typically if people are in favor of Trump or they're in favor of Biden, they think that these types of lawsuits are necessarily good or bad depending on their politics. But what you're pointing out is very important, I think, for viewers to recognize that the executive branch has been overreaching for years and years and years before any of the current administrations. And so to roll back those things, litigation is one of the best tools that we have available to do this. So I commend your organization for doing that. And that also gets into the area of, for example, sanctuary city policy. Because when we talk about the overreach of the executive branch, it's not just on the federal level, it's on the state level as well. And so is your organization involved in any of those litigation efforts?
We have not been involved in that particular area, but I'm very well aware of the Biden executive order that changed something that the Trump administration had done. They had an order in place to prevent sanctuary cities from qualifying for certain kinds of federal aid dollars. And that policy has now been switched. And so the taps have been turned on again for federal money going to these cities that are actively working against federal immigration law by putting themselves out there as sanctuary cities. So that just goes to show you the power of the federal government. We also see lots of places where the Solicitor General's office, that's the top litigating office in the Department of Justice, has switched the government's position in several cases coming from the old administration into the new administration. And I just want to say NCLA has not switched our position in litigation. We've been consistent against the violations of the Constitution, whether they were being done by the last administration or by this administration. But we don't see that same consistency coming from the Department of Justice.
That's really fascinating. And as constitutional conservatives, we should always be on the side of the U.S. Constitution, the correct delegation of authority within the separation of powers in the Constitution, and should be consistent regardless of who is in power and what administration and party. That's absolutely correct. And I think for a lot of people, we tend to only view this through the lens of partisan politics and through the headlines that we see. We don't actually analyze the root issue, which is, can this particular government actor or branch or agency actually do what it's trying to accomplish? And is that something that is constitutional or not? That's a question that should be black and white, but it's often shaded by colors of politics. And so in the last couple minutes that we have with you, Mark Chenoweth from NCLA, I also want to talk to you about the litigation that you have ongoing for International Women's Day and Biden issuing the executive order on guaranteeing educational environment free from discrimination on the basis of sex, including sexual orientation and gender identity. So this was one that I know that court opinion that came from what should have been a conservative court was really frustrating to a lot of conservatives who know that this was an overreach completely.
Yeah, we had two concerns. Our main concern was that that when Congress passed Title VII, and there is this, I think the issue you're talking about is Justice Gorsuch and the way that he interpreted Title VII. But the issue that we have right now is that the current administration has taken the decision in the Bostock case, which was limited to Title VII, and through executive order has tried to apply that holding throughout the government to say that whether you're schools receiving federal funding or whether you're the Department of Labor or whatever other departments of government are involved, that you also have to follow this ruling. Well, it was a statutory ruling that's limited to the Title VII employment discrimination context. It didn't reach all these other areas, and that's just not the way Supreme Court decisions work. You don't get to take one decision and then as the president say, oh, well, this settles this whole question for all time. It was a narrow decision, and they're trying to make more of it than there was. So that's one concern, particularly in the Title IX area. We have litigation going in this area as well, because what you saw in the Obama administration, again, this gets back to guidance, is a Dear Colleague letter went out from the Department of Education to hundreds of colleges and universities telling them that they are not allowed to offer due process to people who are charged with sexual harassment or other violations of Title IX. And as a result, these colleges and universities have lowered the standard of proof. They've prohibited the defendants from learning the charges against them. They've prevented them from cross-examining witnesses. They've prevented them from offering witnesses in their own defense. All the things that you just read the Bill of Rights, and you can see the kinds of things that you should have in the way of due process.
This is such an overreach. Absolutely. And Mark Chenoweth, we're going to have to leave it there. There's so much more that we could talk about the executive overreach. And I hope that people will go to nclalegal.org, find out more about the work of the new American Civil Liberties Alliance, and make sure that you help their organization.